Divine is often thought of as a noun, a thing or entity, or is thought of as an adjective, a descriptive modifier, quite often contemplating God, church, and or religion. Three things fervently rejected by the poor children of one not afraid to burden hell legislator in Northern Virginia, which he is very proud. However, if you have the great fortune, like Congressman Don Beyer, multi-billionaire, to have been educated in a fine Jesuit high school, having been instructed in the Latin and introduction to transitive and intransitive verbs, action words, like the action that is required when faced with the evolutionary pressures of a pandemic, perhaps, you may have had the unique opportunity to study John Milton as bearer of light, who would rather rule in hell than serve in heaven. Finding the poet asking, after he had found his antagonist cast down, if thou beest he, but oh, how fallen, how changed from him who in the happy realms of light, clothed in transcendent brightness, didst outshine myriads, though bright. And had this sophomoric opportunity to muse with fellow classmates about what in hell was so damn funny about that. We're not telling mathematical jokes about pi, of course. But for those whose educational attainments may not have ascended to such lofty heights, let's pause for a few moments to expand our limited vocabulary, shall we? To consider the transitive, or a verb with an object, generally a noun that is acted upon, and intransitive forms, those verbs lacking an object of the verb form divine, or to discover by intuition or insight, infer, such as to divine the truth, to discover or locate something such as underground water or minerals, usually by means of a divining rod, to seek to predict future events, or discover hidden knowledge, usually by the interpretation of omens, and by the aid of supernatural powers, which certainly you have, to practice divination, prophesy, to perceive intuitively. And so when we use an imperative form, or the command voice, like divine comedy, for those who miss the joke, that is a command to discover that which is comical, divine comedy, employing the transitive verb form. But if we say, please divine, we open a world of almost infinite possibilities in the transitive form, the intransitive form. And in divining pleasures, we can delineate at least three distinct categories. One that divines by the power of intellect and reasonable inference. Another that perhaps in a rejection of all that is religious considers the paranormal and supernatural to divine. And on the very far end of the spectrum, we arrive at that which is located in the realm of providence, and that which is eternal and divine. Are we clear? Hello, and how in hell are you? Exactly. As a scientist, welcome to Pandemic. My name is Major Mike Webb. Just another ordinary guy, nothing extraordinary as you may define, and described by the Progressive Voters Guide as having been against the government response to the current public health crisis, derisively, and described by one federal court in the Texas state as a litigation hobbyist. And perhaps when you spend your time at home during a pandemic, bringing multiple cases to the U.S. Supreme Court, because you have nothing else to do, perhaps, like obviously all of us did, such as last, you'll be called a litigation hobbyist. things could be worse. But this action in the federal court in Fort Worth, Texas, involving the Navy SEALs, the Navy Special Warfare Combatant Craft Crewmen, a Navy Explosive Ordnance Disposal Technician, and Navy divers, members of the elite military special operations community, of which I am alumni. Less than 1% of the total active duty uniformed military force just recently brought on appeal to the Fifth Circuit in New Orleans, or Orleans, Louisiana, now presents an intriguing issue on what is often described as the shadow docket, reserved for matters of great public importance, requiring immediate action under Supreme Court Rule 11. And it all began as a petition for leave of court, or request for permission under the Federal Rule of Civil Procedure 24 to intervene in litigation brought by the Navy SEALs against the vaccines mandates, commenced in November 2021. In a prayer for relief, as he made a divine requesting, quote, a declaratory judgment that defendants' vaccination policies challenged in this complaint violate plaintiffs' rights under the First Amendment to the United States Constitution. B, a declaratory judgment that defendants' vaccination policies challenged in this complaint violate plaintiffs' rights under the Religious Freedom Restoration Act. C, a declaratory judgment that defendants' vaccination policies challenged in this complaint violate plaintiffs' rights under the Administrative Procedures Act. D, a preliminary and permanent injunction prohibiting the defendants, their agents, officials, servants, employees, and any other persons acting on their behalf from enforcing the vaccination policies challenged in this complaint. E, an order declaring unlawful, setting aside defendants' vaccination policies. F, actual damages under Tanzan v. Tanvir, 141 S. Court 486/2020, in the amount of pay plaintiffs will lose as a result of defendants' discriminatory vaccine policies under the Religious Freedom Restoration Act. G, nominal damages against defendants in their individual capacities under Tanzan v. Tanvir, 141 S. Court 486/2020, for the violation of plaintiffs' rights under the Religious Freedom Restoration Act. H, plaintiffs' reasonable attorney's fees, costs, and other costs and disbursements in this action pursuant to 42 U.S.C. Section 1988, and I, all other further relief to which plaintiffs may be entitled. Sounds copacetic to you, right? But are you an attorney possessed with their unique powers of divination? Probably not. So let's first review some terms that appear in the plaintiff's prayer for relief to provide a better perspective on why we chose divinely to intervene in March in this action, entering our pleading and complaint that was somehow lost, causing us to attempt again in May. And probably the easiest legalese phrase to define is the reference to 42 U.S.C. 1988, which is related to what is often described as Section 1983 claims, which you may have heard, particularly in cases involving allegations of discrimination, but also other alleged derogated rights, where Section 1983 is what is described by attorneys as an authorizing provision of law. That codification of law that grants a specific right to relief, provides a legal cause of action, civil remedy, you'll often see, or that gives you a right to bring a claim to a court. While Section 1988 is the enabling provision, which tells you exactly what you can request. And in Section 1983 claims, don't expect to become a millionaire, because it only entitles you to a return of what the court deems to be reasonable attorney fees for your case and expert witness fees, to partially reimburse the attorneys that you retained to defend your rights. the end of the day, you get your rights and the attorneys get paid, at least in part. Reasonable fees. There is a prayer under the Administrative Procedures Act, or APA, a provision of law that establishes rules as to how some government agencies may conduct their affairs internally, but it does not cover all government agencies, leaving some exempt. And where the Defense Department and military services are engaged in actions that are defined as purely military, they are exempt, which the Department of Defense has argued successfully to some extent to the Supreme Court in March, resulting in the order that was issued. There is a catch-all declaration in the complaint that the mandates are just simply unlawful. There is a prayer for preliminary and permanent injunction, or for an order for the Navy to cease and desist enforcement of the mandates against these particular service members and now the certified class, that some government action must be stopped against them. Who knew we did so much praying in courts, swearing to tell the whole truth and nothing but the truth? So help us God. And the complaint is capped off at the end with a flourished finale, generally requesting all that for which the plaintiffs and the now certified class had prayed, and such other equitable relief as deemed proper by the courts. And at the beginning of the pandemic, even atheists were found praying, 24%. And at the very beginning of the prayer for relief, in this case, as you may divine, there is a request for declaratory relief, which is exactly what it sounds like, a declaration, like the Declaration of Independence, or an official statement from the court. And in this case, that the vaccines violate the First Amendment, all claiming a religious exemption in rejection of the fetal lines used in the production of these COVID-19 countermeasures. The Religious Freedom Restoration Act, or RFA, with a reference to special relief authorized under Tanzan v. Tanvir, a unanimous opinion drafted by Justice Thomas that had held or concluded that the RFRA's express remedies provisions permit litigants, when appropriate, in certain circumstances, to obtain money damages against federal officials in their individual capacities, piercing the traditional veil, as attorneys say, of sovereign immunity that often bars civil suits against government officials. We hear that often. And in Virginia, we are often find in our courts the statement that sovereign immunity is alive and well in the Commonwealth. And as you can divine in this litigation that remains in the courts for the seals, as well as in other vaccine mandate challenges, just claiming that you should be exempt because of your religious beliefs, sincerely held or not, does not mean that you will win in a court. Pray for relief as you may. And there are several cases, especially dating back to the case brought by the prize fighter Cassius Clay. Found religion became a minister of Islam during the conflict in Southeast Asia for exemption from the draft that have tested the limits of these religious exemption claims. And generally, if there is a legitimate government interest and the government employs the least restrictive means, the government will almost always win in court. This is why you can't tell the police you will not go to jail because it's against your religion. And thinking like a lawyer, divining strategies, tactics, and pertinent jurisprudence was the argument so framed, where then should be the focus of the attack against the vaccines mandates. The legitimacy of the government interest and or whether least restrictive means have been employed. I'm going to need to do some homework. Otherwise, it's too damn easy. One may divine. And in the courts, both state and federal, there is apt to which an attorney might describe as deference doctrine. I defer to you, you defer to me, somebody is over somebody, like sovereign immunity, for which the seminal case taught in any reputable law school is the environmental case, Chevron USA v. National Resources Defense Council, or NRDC, decided in 1984, the very year of Dr. Anthony Fauci's appointment to the NIAID, which basically states a bright line rule that a government agency has been established as an expert in its field. We pay people to do this job, and as long as they are not clearly erroneous in their interpretation of the facts, and an attorney quoting the case of USB United States Gypsum Company will inform you, for your greater edification in pandemic, that a finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. This is below the standard of beyond a reasonable doubt, but it's pretty close. Clear and convincing evidence. And as someone bringing what attorneys may describe as a facial challenge, striking down the entire statute, or bringing what is described as an as-applied challenge, like the one that had been brought by the attorneys for the Navy SEALs, alleging that the vaccine's mandates, as applied to persons claiming a religious exemption, not striking down the entire vaccine mandate, was simply unlawful as to those persons identifiable in that class. If the issue is fairly debatable and it is a tie, you may define that you lose because of deference doctrine. And all of the money paid to attorneys in the world will simply not alter that immutable fact. Take it all the way to Supreme Court if necessary as you may. If it is a tie, you lose. And we may divine from this empirically that a God in heaven simply does not like you. Love notwithstanding. Are we clear? And so, from this rather extended exposition of the arguments for which we had initiated in the U.S. District Court in Texas, initially in March and then later resubmitting in May, only to be rejected by both defendants and plaintiffs, seeking leave for intervention in the mundane affairs of these special operations soldiers, you may well be able to reasonably divine without prophecy the general framework of our issue now raised upon appeal to the nation's highest court on the shadow docket, with just one simple and defined issue as to the actual ownership and origins of a novel coronavirus for which the Navy SEALs and others have sought exemption from the vaccine's mandate. A facial challenge. If there is no legitimate government interest, one may reasonably divine that the regulation must of necessity go away. But to make that argument, Pastor Hemming Jacobson and his learned attorneys challenging a smallpox vaccine mandate in Cambridge, Massachusetts during an epidemic in 1905, quickly discovered at the outset of their arguments before Justice Harlan these words: "We pass," without extended discussion, the suggestion that the particular section of the statute of Massachusetts now in question, section 137, chapter 75, is in derogation of rights secured by the preamble of the Constitution of the United States. Although that preamble indicates the general purposes for which the people ordained and established the Constitution, it has never been regarded as the source of any substantive power conferred on the government of the United States or any of its departments. Such powers embrace only those expressly granted in the body of the Constitution, and as such may be implied from those so granted. Although, therefore, one of the declared objects of the Constitution was to secure the blessings of liberty to all under the sovereign jurisdiction and authority of the United States, no power can be exerted for that end by the United States, unless, apart from the preamble, it be found in some express delegation of power or in some power to be properly implied thereof. Years of training, practice, and apparently Pastor Jacobson's attorneys never quite divined that lesson on the preamble to the Constitution. Perhaps they missed schoolhouse rock. And like Dr. Fauci has said of a novel coronavirus, that pastor who had retained these attorneys, unknowledgeable of the law himself, was unforgivingly at their mercy in that epidemic, as you may divine from his tragic outcome before the nation's highest court, where he lost. And, making matters even worse, Judge Harlan quite directly let them know, collectively, together as a team, in very stern reprimand in a vaccines case, that the only competent evidence that could be presented to the court to prove these propositions was the testimony of experts giving their opinions. In court, you may, from just this case, divine that it is not about your misperceptions of your rights about which you have not even been informed in a law school class, nor your precious little feelings about the pandemic. We all have feelings in pandemic. Many get their feelings hurt in pandemics. And unless you wish to lose your money to attorneys and hurt your pride, at least the Army says, with regard to safety and composite risk management, that the first step in risk management is to identify the hazards associated with a task, like even going to court, or subtask, operation, process, facility, or equipment, in clear and quantifiable, definite terms. Just as a commander will express his intent in a military operations order after the statement of the general mission, and only then can one reasonably calculate measures so as to mitigate or prevent that risk or threat. Zig Ziglar says that it is very difficult to hit a target that you cannot see, and it is impossible to hit a target that you cannot have, that you don't even have, unless you want to rely on your supernatural powers in the paranormal. And exactly as a scientist graced by the powers of empirical observation over 2 years into a pandemic and its evolutionary pressures that appear to have worked quite well for a novel coronavirus, a single strand of RNA that even Dr. Rochelle Walensky, a medical doctor, has said it isn't stupid. How well has that, however, worked for you thus far? Can you divine? Can you look like an intelligent person? This briefing is unclassified. As you were, my name is Major Micro. By God, I am running for U.S. Congress. This year, make the right choices, and we shall make America great again. Honest. Carry on. This advertisement was authorized by Mike Webb.